Good morning and welcome to News Channel 10. This morning we are graced with the presence of Emily Andrulis and Eibhilin McKenna, who will be speaking about an interesting case coming out of Kansas.
Thanks, Joey.
Welcome, ladies, and thank you so much for being here.
Our pleasure. It's 1953, and I'm sure you've all kept the Topeka, Kansas case on segregated schools in the back of your minds. 2 years ago, in 1951, a class action suit was filed against the Board of Education in the city of Topeka, Kansas. Wow. The plaintiffs consisted of 13 parents and 20 children who attended an all-black school in the Topeka School District. They filed the suit hoping that the school district would change its policy on racial segregation. The parents were recruited by the Topeka National Association for the Advancement of Colored People, led by McKinley Burnett, Charles Scott, and Lucinda Scott. The named plaintiff for the case was Oliver L. Brown. He is a parent, a welder in the shops in the Santa Fe Railroad, an assistant pastor at his local church, and an African American. He was convinced to join the lawsuit and proved to be the perfect man for the job. Brown's daughter, Linda, a third grader, had to walk 6 blocks just to get to her school bus stop, to then ride the bus to her black segregated school, Monroe Elementary, while Sumner Elementary, a white school, was just 6 blocks from her home. In the fall of 1951, the parents of the 20 children attempted to enroll them in the closest schools to their home, but each were denied enrollment and told they had to enroll in the segregated school. This prompted the class action suit to be filed. At the district level, the court ruled in favor of the Topeka Board of Education, citing the U.S. Supreme Court precedent set in the Plessy v. Ferguson case of 1896, which we'll get into a little later, and saying that both schools were equal in regards to transportation, buildings, curriculum, and highly qualified teachers.
It's funny you talk about that because earlier this year, the case and 4 similar ones from around the country was heard by the Supreme Court, but the issue was unable to be decided upon, which is, ridiculous. Last week, it was reheard and the final decision was unanimous. It was ruled unlawful for there to be separate public schools for white and blacks under the 14th Amendment Equal Rights Protection Clause.
Thank gosh.
It's just logical. This Brown v. Board case may have just sent the civil rights movement full speed ahead and has definitely given African Americans hope that separate but equal on all fronts will be changed.
Definitely.
This landmark case has opened doors for schools to all people across the United States. It has allowed people of all colors to have equal opportunity to a free and public education no matter where they live or what their race is. They're just kids. Come on. Already, though, the aftermath of this ruling has been difficult to say the least. Topeka schools will be integrated, but there has been speculation already that in the states around the country, school districts will close the schools before they desegregate them, which is just out of this world. It has not been easy transition, and tension runs extremely high. All we can do is hope that eventually everyone sees that segregating blacks from whites in all situations is harmful above all else, and everyone should be given an equal opportunity.
Amen. What really astounds me is that this poor little third grader had to walk by herself, practically past the white school, all the way to her bus stop to then go to her school.
Ridiculous.
It's crazy, I know.
I'm really interested about that Plessy v. Ferguson case. Let's have Joey tell us a little bit more about it.
Sounds good.
Wow, Emily and Eibhilin, what a fascinating case. I'm so happy that the court ruled in favor of the Negroes. Now let's talk a little bit about Plessy versus Ferguson. In 1890, the state of Louisiana passed a law called the Separate Car Act that required separate accommodations for blacks and whites on railroads, including separate railway cars. Concerned, a group of prominent black, Creole, and white New Orleans residents formed the Committee of Citizens, dedicated to repeal this law. They eventually persuaded Homer Plessy to participate in an orchestrated test case. Plessy was born a free man and was an octoroon, that is someone of 7/8 Caucasian descent and 1/8 African descent. However, under Louisiana law, he was classified as black and thus required to sit in the colored car. On June 7, 1892, Plessy bought a first-class ticket at the Press Street Depot and boarded a whites-only car. The railroad company, which opposed the law on the grounds that it required the purchase of more rail cars, had been informed already as to Plessy's racial lineage. Additionally, The committee hired a private detective with arrest powers to detain Plessy to ensure he was charged for violating the Separate Car Act, as opposed to a vagrancy or some other offense. After Plessy had taken a seat in the whites-only railway car, he was asked to vacate it and sit instead in the blacks-only car. Plessy refused and was arrested immediately by the detective. As planned, the train was stopped and Plessy was taken off the train at Press and Royal Streets. Plessy was remanded for trial in Orleans Parish. In a 7-1 decision handed down on May 18, 1896, the court rejected Plessy's arguments based on the 14th Amendment, seeing no way in which the Louisiana statute violated it. In addition, the majority of the court rejected the view that the Louisiana law implied any inferiority of blacks in violation of the 14th Amendment. Instead, it contended that the law separated the two races as a matter of public policy. When summarizing, Justice Brown declared, "We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it." While the court did not find a difference in quality between the whites-only and black-only railway cars, this was manifestly untrue in the case of most other separate facilities, such as public toilets, cafes, and public schools, where the facilities designated for blacks were poorer than those designated for whites. Justice John Marshall Harland, who decried the excesses of the Ku Klux Klan, wrote a scathing dissent in which he predicted the court's decision would become as infamous as that of Dred Scott versus Sanford. As heralded as this dissent may be, in which Harlan called for a colorblind constitution, it should be noted that he did not view all races as equal. In his dissent, Harlan highlighted the plight of blacks by pointing out that the Chinese, a race he viewed as inherently different, could still ride with whites. "There is a race so different from our own that we do not permit those belonging to it become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race," he wrote. New Orleans historian Keith Weldon Medley, author of We as Freemen, Plessy vs. Ferguson, The Fight Against Legal Segregation, said the words in Justice Harlan's great dissent originated with papers filed with the court by the Citizens Committee. The case helped cement the legal foundation for the doctrine of separate but equal. The idea that segregation based on classifications was legal as long as facilities were of equal quality. However, Southern state government refused to provide blacks with genuinely equal facilities and resources in the years after the Plessy decision. The states not only separated races but, in actuality, ensured differences in quality. In January of 1897, Homer Plessy pleaded guilty to the violation and paid the fine.
And on the recent ruling.
Hello, folks. I'm back here with Mrs. O'Neill, who is a current teacher in Topeka, Kansas, and we thought it would be a good idea to get an educator's view on the recent ruling of segregated schools. So tell me, Mrs. O'Neill, how do you feel about the segregation of blacks and whites into one school?
I think it's a good thing. I think that it's about time that everyone came together and realized that everyone in the United States needs an equal education. So everyone's entitled to
An education.
an education.
Exactly. And why
You got
should
it.
race and color separate
That's right.
that education? Wow. Thank you for that astonishing opinion.